Every day in the USA, people find themselves in court.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Olga Terry Fowler. It's case number 2023 CR 288. Ms. Fowler appears from what appears to be a detention center Zoom location. Brett Sweeney appears as prosecuting attorney for the state of Kansas. James Watts is defense counsel. Court's docket notes indicate that the matter came before the court for evidentiary preliminary hearing on May the 8th. After hearing testimony from several witnesses, the court did determine that there was probable cause which existed for a charge of distribution of a controlled substance, but took the causing death portion of the original charge in this case under advisement. Court also established an arraignment date for today and stated back on May 8th that the court would announce a decision on the level 1 charge at that time. That level 1 charge being, of course, distribution of a controlled substance causing a death, a level 1 person felony. Court will review pertinent evidence that was submitted at the preliminary hearing. Dr. Scott Kipper testified in the case that fentanyl was crucial, played a crucial role in the death, that the cause of death was essentially a mixed drug toxicity. However, on appropriate and effective cross-examination by Mr. Watts, the doctor also testified that it was a combination, that he couldn't isolate fentanyl, that fentanyl was a portion of the cause of death, but he couldn't say that but for fentanyl involvement, the decedent wouldn't have died. Court, upon its research, has determined that there is a controlling case on this point. It is Burridge versus United States, 571 U.S. 204, a 2014 case. I will read from pertinent parts of that decision, particularly the syllabus. Portion that I think is appropriate here. I will begin with the facts of the case, which are summarized there. In Burridge, a drug user died from heroin supplied by Burridge. Burridge received a federal sentence enhancement due to his distribution of a drug which caused the death. So the issue in that case was, did that defendant qualify for that federal penalty enhancement? The syllabus goes on to say, because the Controlled Substance Act does not define results from, the phrase should be given its ordinary meaning. Ordinarily, that phrase imposes a requirement of actual causality, i.e., proof that the harm would not have occurred in the absence of, that is, but for the defendant's conduct. Similar statutory phrases, because of, based on, and by reason of, have been read to impose a but-for causation requirement. This court declines to adopt the government's permissive interpretation of results from to mean that use of a drug distributed by the defendant need only contribute to the aggregate force mixed drug intoxication that is itself a but-for cause of death. There is no need to address a special rule developed for cases which in multiple sufficient causes independently but concurrently produce death, since there was no evidence that the heroin use was an independently sufficient cause of his death. And though Congress could have written the law to make an act or omission a cause in fact if it was a substantial or contributing factor in producing death, Congress chose instead to use language that imports but for causality. The court finds that the language of the statute passed by the Kansas legislature essentially uses the same language as what was under scrutiny in the federal law in the Burridge decision. In fact, the charging document in this case states that death results from the use of the controlled substance. The court sees no reason not to apply the Burrage rationale here. The court finds in this case that the legislature could have written the law to say that if the death is caused substantially or as a contributing factor by the production and distribution of the controlled substance, that it would lead to a level 1 offense. But they didn't use that language. They used language similar to what the federal government used, the Congress used, that was analyzed by the Supreme Court in Burrage. The court will apply the Burrage rationale and makes a finding in this case that the fentanyl that was obviously the subject drug that the state was relying upon here to file this level 1 charge, it must be an independently sufficient cause of death, not merely a contributing or substantial factor. Because the court is bound to and does follow United States Supreme Court precedent, the court applies the Burrage rationale to the facts of this case, and the court will not bind over on the level 1 charge in this particular case, finding that essentially United States Supreme Court precedent precludes it, given the specific facts of this case. However, with that ruling made, as announced at time of the evidentiary preliminary hearing, the court does find that based on the charging document in this case, distribution of a controlled substance is a lesser included felony. Therefore, it is the intention of the court at this time to bind over on the lowest severity level of distribution under Kansas law. As I understand it, if the state is indeed relying on fentanyl, and it's clear to the court from the evidence that the state is, that I think that we're looking at the application of KSA 654107C9 and the definition of opiate in 215705A1. The court does bind over at the lowest severity level, a level 4 drug felony. And the court will require the state, and I'll establish a deadline here in a moment, I will require the filing of a new charging document in this case, which specifies by name the drug that the state's relying upon, such as fentanyl. And then the court will also require that the new charging document specify the subsection of KSA 215705 relied upon, and I think referred to in the original charging document, and then a specific penalty section citation as well. Mr. Sweeney, I know that you've got a number of cases and a number of responsibilities. What is a realistic time frame for the filing of this amended charging document?
Your Honor, we could probably have something filed early next week, Monday or Tuesday. I just one quick point of clarification, though. I just want to make sure that I've got the court's ruling accurately. The court did bind over on 275705 or 215706, the distribution or the possession.
I'm just looking at your charging document. You say she distributed a controlled substance in violation of 215705.
Right, that's the distribution. I just wanted to make sure that that's what the court's ruling was, and then I believe that it would be 215705A, and then I believe it's likely going to be a level 4 felony.
All right, but I can't bind over on anything but that at this point, since that's the lowest severity level and you didn't specify any enhancing facts in your charging document. So that's what the bind over is for at this point, is a level 4 drug felony. All right, Mr. Watts, this was originally set for arraignment, but in light of the court's ruling today and the requirement that the state file a new charging document with more specificity regarding the controlled substance distribution charge, which your client was bound over on, do you wish to defer arraignment to a later date, or do you want to proceed with arraignment now?
And Your Honor, myself as a lawyer, I don't know that I have a preference. I guess I'll defer to Ms. Fowler. Do you have a preference to proceed to arraignment today?
And I will just simply say this before we go any further. If your client desires the charging document to be read to her, we can't proceed because
Understood.
I don't have it to read.
And given that, Your Honor, perhaps it's better off to set it to a later date.
All right, I would tend to agree. I would tend to agree. I'm not trying to delay things for your client, but. And I appreciate your office's commitment, Mr. Sweeney. I'll look for an appropriate date. I'm going to try to avoid conflicts with other courts. Given Mr. Sweeney's optimistic appraisal about when he can have his amended charging document on file, one thing I could offer is Friday, May 31st, 2 weeks from today, at approximately the same time frame.
That I can do, Your Honor.
I could do 1 o'clock on that date.
I can do that, sir.
That'll work for the state as well.
All right. I will reset the Fowler arraignment for Friday, May the 31st, 1 o'clock p.m. by Zoom. Defendant must fully participate by audio and visual means in that proceeding, Friday, May 31, 1 o'clock p.m. for arraignment in her case. And I will expect that that amended charging document will be on file and be available to the court and opposing counsel prior to that date.
For sure.
All right. Mr. Watts, is there anything further we need to address today?
Nothing else, Your Honor. Thank you.
Mr. Sweeney, anything further at this time?
No, Your Honor.
I trust that the defendant has been able to see and hear everything adequately here this afternoon.
Yes, sir. Does that mean that my bond is gone, or
No, it doesn't mean that.
it
No,
doesn't?
it doesn't mean that.
Okay, is there any way to get it lowered?
It's set at $10,000 cash or surety now.
Yes, sir.
Well, she's no longer facing a level 1 charge.
But Your Honor, just for the record, I would note that there's been multiple issues with Miss Fowler over the course of a couple of different cases. She's on probation for another case that she has a show cause on at 2:30. So obviously there's been some problems with her both on probation and bond. The state would object to a modification.
Well, I note that at one time, back in December, this court ordered a no bond hold due to a failure to appear.
And she was in treatment at that time, Your Honor. And I know that doesn't excuse a no bond hold.
All right, and then I did take that into account apparently, or some judge did, in reinstating a bond at 10,000 cash or surety. I'm going to leave it where it is at the current time. Still a very serious charge which is pending in this court. And there has been a previous failure to appear. So the court will deny the request at this time. And we'll take this up again on May 31st at 1 o'clock. All right. If there's nothing further at this time, the Fowler matter will currently be in recess, and this meeting may be ended for all at this time.
Jerry, just so you know, I've got you on the visit list next